All right, so first thing we're gonna do is I'm gonna pull up a little whiteboard here, and we're gonna go to our whiteboard.
Okay.
And what we're gonna do here is um, I'm gonna break down what is a trust. Okay. Um, please don't draw on there. Just keep your fingers off the screen or whatever. All right. All right. I just don't want to add any confusion to this. How do I do this? That way. Okay. Now, okay, good. Just making sure this works. Okay, so here's what we got. We got someone here, right? Man or woman, doesn't matter.
Mm.
Okay, now here's the thing. They have something. Like let's say this house. Okay. And they have kids, right? Right, they got a couple kids here. And boy, do they love their kids, right?
I still.
Right? Now, this house has value, right? But not just a monetary value. It has a value to the children as a place to live, right? So what they do is the father here, he becomes what's called a grantor. It's his house, and he's going to grant or give this house to his children because he finds out that when he dies, if he has this house in his name, when he passes away, these kids are going to have to shell out tons of money for the house. For the house that they already have. They have to pay taxes on it, right? They have to pay taxes. They're going to have to pay taxes on his death, everything, all the money he's had. They have to tax because it becomes that all that money becomes goes from him to them under a will. And all that's taxable now because for them it's considered gains, right? Capital gains. So
Okay.
they tax them on his money that he was already taxed on. But the government thinks, well, we can do this because it's not their money; it was his money. Now we can tax it again, right? So it's a scam. So what does he do? Is he takes his house, he takes his bank account here. Let's say this is his bank account, right? A little vault. Okay, you get the idea. I know I'm a master artsman here. Okay, so here's his vault with lots of gold, silver, cash in there, and he puts it into a trust. Okay. Now, this trust is just a legal vehicle, okay? That's going to hold the property. Now the trust is the owner of this stuff. Trusts cannot die. They're not living human beings. So when he dies, well, guess who owns the house and this and all this money?
Trust.
That's right. So there's no transfer anymore, meaning that there's no taxable event. So the kids get to save their money, right? But this also teaches the kids, oh, look what dad did. He's a smart guy. We're going to do that too, right? So dad, if he's smart enough, he's going to teach his kids how this stuff works so that way. Now, what they're called here are they're called the beneficiary, okay? Because they're the ones that are going to benefit, right? I swear this is actually what my handwriting looks like on paper, like with a pen. All right. Um, the they're beneficiaries because they're going to benefit from this trust. They benefit by living in the house. They benefit because they can spend the money that's in here. Now the trust can limit. Now when you write a trust, the trust is like the law of all the items inside of here and the parties inside of the that are a part of this trust. So we have a beneficiary who benefits from this property. We have a grantor who funded the trust, who put the money or valuable things in here. Okay. And then you have someone who runs the trust and they're called a trustee. Okay. Now, in this scenario, the dad could also be the trustee. Okay. And that's totally fine. In this scenario, he is the trustee, meaning that he is going to do everything he can to ensure that the beneficiaries benefit from this trust property. Okay. Everyone can still see that?
Mhm.
So he could say, you know what, I don't want to be the trustee. Maybe he's much older. Maybe he married a younger woman, right? Like that does happen. Some guys marry younger women, and they get to a point where they're like, you know what, I'm gonna make my wife the trustee, right? So he makes his wife the trustee over here because he's thinking, well, my health is starting to decline. It's not going very well for me. I might as well just make her the trustee. So that way, if I pass away, she's good because the trustee can actually has permission to use the property in here as long as they don't take away the beneficiary's beneficial interest in it. Okay. Which
Yeah.
is which depends on how it's written out in the trust. Let's say there's $1 million in this account, right? The beneficiaries might be entitled both to 49%, right? Which would leave 2% left over for the trustee to be paid or pay her bills or whatever she's going to do with it. So the trustee would, but it depends on what you write in the contract for the trust. So now the wife is now the trustee. The grantor passes away. But what happens to all this? Nothing's changed here. Okay. But she might determine, hey, I'm going to make one of these two beneficiaries or maybe someone else the next trustee in case I pass away. Right. Now this is an elementary idea of things you can do with a trust, right? So now another thing that can happen because of this situation is this. Let's say this guy, let's say he has some situation over here. Let's say he runs a business and now someone wants to sue the business, right? Someone's trying to sue them in court. Uh, and they say, we're going to take you for all you got. Well, they can sue him for everything that he has in his personal name, right? His personal bank accounts, right? Maybe his car is in his name, right? Beep, beep, right? Like my car, just a nice car.
Oh, yeah.
Don't judge. All right.
Ni-
But there's his car. So they can sue him. This guy's over here. You see, he's angry. He's got arms akimbo here. He's angry. I'm going to sue you. So he wants to sue him. He wants to get lots of money from this guy. Right? Now, here's the thing. This grantor, remember, he put the house and the majority of his savings into this trust. So when they sue him, everything that's in that trust is not part of the lawsuit. It can't be considered part of the lawsuit because it's no longer his. Legally, he does not own it anymore. Legally, the trustee over here owns it under the trust name. So even though the trustee is the one that's responsible now, they don't have a claim against the trustee. They don't have a claim against the trust. They don't have a claim against the beneficiaries. All this stuff that's in this trust is untouchable to this lawsuit. Even if he was in his car and he hit somebody with his car, all they could sue is whatever the owner of this car may be able to give them out of his own accounts. If he's got money here, like here's his other vault, right? And it looks like a son. He wants to sue him. Well, I can only sue him for what he has here because that's in his personal name. Now, if this guy was really smart, he would have none of this stuff in his name at all. All of this stuff would be moved over into trust. And when they try to sue him, he goes, I'm broke, I'm poor, I'm really sorry. I'll do what I can to help, fix up the damages. But the courts couldn't even make him pay, right? And there's a real good example of this. I have a friend who, when his daughter him and his wife had a daughter. She was born. The wife, they were both in the military. She went AWOL like 3 months after giving birth and took off. And he was like, he was devastated. He lost the the love of his life. His daughter is a baby, and now he's raising his baby as a single father. He was losing his mind. He didn't know what to do. So what he did was he came up with an idea. He's going to do everything, put everything into trust, make sure that his daughter's protected, right? And as the years went by, he just started operating more and more in this trust and moving things into the trust, and everything he did for his daughter was through that trust, right? Like he was the grantor and trustee of this trust, and his daughter was the beneficiary. And it got to a point where all his business, like he left the military, got a job outside in civilian world, and started just using this trust for everything. In fact, all his business associations, all his business dealings was done through trust, not even through his name anymore, because he felt it was a little easier. He felt less liability on things. And what happened was the mother came back and said, "I'm taking my daughter." And she came, and the daughter was about 7 at the time. So he raised her for about 7 years alone. She came back, took the daughter, disappeared. He got a notice, he got a letter in the mail saying that he owed child support. And he was like, "I don't have any money." And the court looked, and they went trying to look for bank records. And they said, "Your last known account was from, I think, 2018. Please update," or 2017 or something like that. It said, "Please update us on any bank accounts that you currently have." So what the court was trying to do was take money out of his personal accounts, but he didn't have any. He said, "I'm sorry, I have no personal accounts. I don't know. I have nothing to show you. I don't have any accounts of my own." And the court came back and said, "Okay, well, you can't, obviously you're in poverty. You can't pay child support. So we're going to waive the child support." So he doesn't pay any child support to this day. The mother's freaking out, right? Wants to give the daughter back to him because, well, she only took the daughter to get money. She was just hoping to live off of his child support payments, right? And but he's just fighting to get her back, right? That's what he wants to do. He wants to get her back, but now they're going through this big battle. That's what that's what they're going through. But one thing is, the courts keep standing on the fact that he has no money. They can't make him pay if he has $0, because he has no money in his name. None, zero. So that's another benefit to trust. Now, what I want to do here, all right, so we have our three elements. We have the grantor, who funds the trust, right? Either with money or property or things of value. So it could be anything of value. Okay. You have the trustee, who manages the trust. Okay. And then the beneficiaries, the ones who gain, who get the benefits of the property of the trust. All right. So now I want you guys to unmute one at a time. Just give me one purpose that you would have for doing a trust.
Hey, can I ask a quick question before we go on?
Yeah.
So if he is the grantor, and you said he could be the trustee also.
Yeah.
Okay, so let's say he gets in an accident. Can they go after the trustee as him being the trustee?
No, their claim is against the driver, not the trust.
Okay, so even though he's the trustee, they can't touch him, even if he's the trustee.
They can't take the trust. They can sue him, but not as a trustee. They can only sue him as a man.
As a man, okay.
They can't sue the trustee because they don't have a claim against the trust. It's not the trust that got into the car accident. It's the man that did.
Right, okay. Just want to make sure. Okay.
Yeah. But this is something I do. One of the things that we do is, like, people want to put cars into trust. And I go, okay, if the car was in a trust, let's say, and you do get into an accident, it could open up the door to the trust being penetrated. So what we do is we set up a trust just for cars, a car trust just for cars. So that way you can have your car in a trust, right? And then if they want to sue the trust, all they're going to get is the car, because that's the only thing that's in there. Okay. All right. Now, Does anyone here have a purpose for utilizing a trust or something they wanted to do with a trust?
Well, asset protection, but I do have a question. Are we talking about irrevocable, non-revocable, irrevocable, revocable, or, and also common law or otherwise?
Well, we're just talking about trusts in general, and we can get into the different types of trusts and what they do.
Okay, okay.
All right, so let's say revocable. So revocable trust. Okay, this would be a trust. Oops. This is a trust that the grantor can change at will and act as the trustee for. Okay. Upon death, this trust can become irrevocable, meaning that it can't be changed. That's not every scenario. If we're talking about like a living trust acts like kind of like a trust and will, a will and trust, where once you die, that trust, the way that trust is, that's it. It can't be modified or anything after that, and everyone has to abide by it. Okay. So that's a revocable trust. Like, so I have a revocable trust. Like, I have a school. The school is actually a foundation, and then the foundation has a trust that manages all its money, right? It also holds all the physical things, like it holds the guitars that are for sale, and it holds the other instruments, accessories, and stuff like that that are for sale. Um, that's what this trust does here. When the trust takes money, though, it's gonna, it's a revocable trust. So at any point in time, I can decide to dissolve the trust and say, forget it. I can do amendments to the trust, which I do all the time. But when you're dealing with an irrevocable trust, okay, an irrevocable trust, all right, is a trust that cannot be easily modified. It could be modified, but in an irrevocable trust, one issue is that you need the approval of the beneficiaries to modify it.
Oh,
Right? The trustee cannot be the grantor. Okay, that's another rule about these irrevocable trusts. When a grantor puts stuff into an irrevocable trust, he is forfeiting the right to the property forever. It's no longer his in any way, shape, or form. In a revocable trust, it could be considered to be his still because he could always take it back. So let's say I have a guitar. Let's say it's a very expensive $5,000, $10,000 guitar. I put it into this revocable trust, right? The beneficiary is like maybe some kid who uses it for playing shows and doing recordings. And then one day I say, hey, I need my guitar back. I'm revoking this trust. So I take the guitar back. That's it. End of story. In an irrevocable trust, same scenario. Once I hand that guitar over to that kid who's going to use it for recordings and shows, it's out of my hands forever. That's it. It's gone. It's no longer mine. In the case of like an irrevocable trust and the grantor having a home, though, the grantor could, right, have a life estate in this house and be deemed like, yeah, even though it's an irrevocable trust and he's the grantor, he gets to live in that house until he dies. Okay. So he can always up and leave if he wants, right? Move somewhere else, right? Get another house, but that house is still in that trust. But he can just decide to stay there for the rest of his life and live there, and that's that. So those are some clauses you could put into an irrevocable trust. All right. Did that help clear that up?
mhm.
Joe,
Yeah.
so for the revocable trust, you can use it for everything, like pets or cars or home.
Yep. Oh yeah. My suggestion with people, if you're brand new to trusts, start with a revocable trust, and I'll show you why. Um, Here's the trust. Look how big this thing is. Now the trust is not that big. The trust is only a few pages long in reality. But all these, because this is an operating trust, it's going to be much bigger, meaning that it does business and stuff like that. So there's a lot more stuff to it, right? But the trust is only a few pages long. It's in here. But if you can see, like here's amendment number 1 to the trust. So I did an amendment to the trust, just like the way the Constitution is written out in articles. Your trust is going to be written out in articles. Those articles govern the laws, like they're the laws of the trust. The trustee is bound by those, and the grantor can either make them up or agree to those rules, right? But once the trust is complete, a property is put into the trust, now those rules operate. In a revocable trust, you can create amendments to it. Those amendments can alter or further define or reform something from the original trust agreement. Okay? Like adding a new trustee or firing a trustee. Let's say you hire someone to be a trustee and they're just a terrible trustee. They forget to, put data in the books. They don't give things out to the beneficiaries when they're supposed to. You're like, what the heck is this? Right? Now, I bet in probably most people's cases, like they're trying to do trust, your trust is not going to be an operating trust like this. It's not going to be that complex. It's going to be much simpler. You're just holding property, maybe once in a while doing this or that. You're never accruing a tax liability for the most part. If you put your house into a trust, it does not exempt you from property taxes. I'll just say that because some people think, oh, I'm going to put my house in trust, so I won't have to pay property taxes. They'll send the bill to the trustee. That's what they're going to do. So, yeah.
Okay.
Yeah, I know. People think that, and then I'm like, nah, it's not like this magical thing that just makes all that stuff go away. All right, so we have our revocable, irrevocable trust. Okay, now common law trust, right, is the same thing as a revocable trust or irrevocable trust, right? It's just that this trust is based off of certain principles and stuff like that of the common law, right? But the jurisdiction would be, and that's another thing. Okay, and this is a big thing that people have to understand. Like you have to choose your right jurisdiction for your trust. Okay, and if like let's say you live in Oklahoma. Okay, so I live in Oklahoma. All right, and you can pick that to be the jurisdiction you trust. There's no problem with that. But as you learn and refine your ability under doing all these amendments to your revocable trust, you can learn about how to build an irrevocable trust and then find out, hey, could I make my trust in a different jurisdiction? You absolutely can. So, like for instance, a lot of these banks, like I live right by New York City, so there's a lot of banks. Like the bank headquarters are really close by. Some of them, they're like physically located in Manhattan, which is 10 minutes from here. And some are located, but they're incorporated in New Jersey or Delaware, where they have no address. And those banks actually operate as trusts, right? Those are operating trusts. So what they've done is they've created, well, the trust is in this jurisdiction, but we're physically located over here. You see what they've done? They've created a jurisdictional situation here where now you have to go meet them at their jurisdiction, which if it's Delaware and you want to sue this bank, you have to go to Delaware and sue them. And they go, oh, we want to take this into our court of chancery in Delaware. And in Delaware, they have courts of chancery. This is why a lot of those big banks are incorporated in Delaware for that specific purpose. New Jersey is another one for the same reason because New Jersey also has courts of chancery. These courts of chancery are these courts that deal in equity and have their own procedures, rather than in common law or law, civil cases where it's just like there's these rules and you just follow these rules. Equity is different because it's basically the judge gets to decide what's fair for both parties. And he looks at all the situations and says, well, let's do a little give and take. Let's make things fair for people and let's work it out this way. So once you're dealing with equity, if like, let's say somebody was looking at going to jail for securities fraud, why don't you put into a court of equity, jail's off the table. That's it. So that's why they like stuff like that, because a lot of those dudes would end up in jail if they went to like a regular civil court. They'd end up in jail because they would go from civil to criminal jail because they are committing securities fraud every single day. That's why they incorporate in Delaware, move everything to courts of chancery. They do what's fair for everybody, and then it equals out. They never go to jail. That's the truth about why these big people who do steal like millions and millions of dollars don't end up in jail, except Bernie Madoff, because apparently he didn't have his head on straight, even as a crook. But all right, so
Joe,
yeah,
is an example of what you were saying right now, mortgage, the mortgage servicers.
yeah. Okay, so the mortgage servicer, that is, I mean, first of all, read your mortgage and promissory note very carefully. If you read it very carefully, look for where they told you that they gave you money, and you'll find that it's not written in there anywhere. It never says anywhere that that bank ever gave you any money. All it is a note saying that you're going to pay them money, but they never paid you. They never loaned you anything.
It's a credit, yeah.
Yeah, but they didn't loan you any money, so there's nothing to pay back. Well, that's not the securities fraud part of it. So that's its own deception. The securities fraud part of it is when they sell that promissory note to two different people at the same time, or three different people, four, right? Or if they put into two different asset-backed securities and they create bonds off of that. That's where the fraud lays. And they do that stuff all the time, because when we tried to pull this stuff out of them in court cases, they'll suddenly want to dismiss the case. They don't want to get involved anymore. They said, we withdraw and we reserve the right to sue again later in the future. I haven't seen any of them ever bring any cases back after we did stuff like that. So they usually stop the foreclosures and then that's it. They just don't hear from them again. But that's a whole other.
That's what I was thinking of doing with the home. Because they try to claim that they have power of attorney,
They do.
and that's no full disclosure there from the beginning.
Well, they'll tell you should have read the fine print. That's what they'll tell you. Because it is in there. That's in there. That's why they get away with that.
Can I ask something?
Yeah.
So that's kind of been bothering me for a little while. So you're saying that the banks don't loan you any money. They don't give you any money. But if you were to, let's say I say, Joe, I want to buy your house, and they said you want 200,000. You would receive 200,000, and I'd be on the hook for that 200,000. You'd be getting money, and you could go to, wonderful state of Illinois, right? So to speak. So how is it that I would not owe that money to the bank?
Because you paid the homeowner. Like if you went to the bank to pay me for the house,
Yes.
right? That promissory note is what funded the account that they paid me from.
Oh, it was the belief that I would pay that money to the bank.
The belief is this. The belief is that the bank took its own money, gave it to the homeowner, to the seller, and then had the seller give you the house. But in actuality, the bank never had any money. They gave you a promissory note. You signed it. They put into an account, and then that account got funded. They paid out the homeowner, and then what they did is they sold the note. They never lent you. No money came out of their accounts to give to the homeowner or to the seller for the house.
So how did you get money to come to Illinois then?
Wait, who's who? The buyer or the seller?
So you're the seller. You
Uh-huh.
have 200,000 now that I signed a note for to the bank.
What's this?
A promissory note, a dollar bill.
It's the same thing. It's the same thing. How many signatures are on here?
Yeah, let's see. Not mine.
No, how
Two.
many? How many?
One, right?
Oh,
Let me
nope.
see it. Let me look at mine.
You
Uh,
can
One, two.
yeah,
Two.
Treasury of the
You-
United States,
two ways through that.
two of them, right?
Yeah, look, on the front,
Yes.
someone endorsed it, and someone redeemed it on the back. It's a redeemed promissory note. Well, partially redeemed. Now we can trade with this because it's payable to bearer. Same thing like the note that you got the mortgage from. They just needed you to sign it so that way they can pay it over to someone. And then they say, it's like this. Let's say I'm the bank, right? And I give this dollar bill to you to give to Mirka. I go, here, I'm going to give you this money for the house. Okay.
Mhm.
So here's the, now, and now Mirka gets the money, right? I say, hey, but I want you to sign this thing first. I say, hey, you sign right here. Okay. And then I'm going to give this to her. We're going to pay for the house now. But you got to pay me back.
I get it. Okay. All right.
You're like, well, why do I have to pay you? I mean, like maybe you get a little cut because you're like a middleman, right? They could get a little something. I don't see a problem with that, but how much are they asking for? They're asking for more than the house value. They should be getting less than the house value because, face it, you are the one now. And here's the, I mean, fractional reserve banking turns into a whole other thing. Once you hand that the promissory note over to them, it's 10 times the amount on their books. Okay, so they turned that $200,000 house into a $2 million transaction, just like that.
Right. I gave Merca the dollar instead of using the bank. Or I could have said, Merca, I'll pay you every month. And I really didn't need the bank. Right?
Yeah,
Yeah.
that's private. Instead
Yeah.
of doing commerce, you're doing in the private.
Okay. All right. That was just a question. Okay,
Yeah.
we can go on.
And it's not really about trust, but all right. So let's talk about. Anyone have any questions regarding trust specifically, not other things?
I have one more.
Is
With
it
the
about trust?
yeah, you said that the trustee, so the grantor gives it to the trustee, right? Let's just say, and you just mentioned it, so that's why I was thinking about it. If the taxes aren't paid, they can go after the trustee to pay the taxes. Well, if you damage somebody with your car and you're the grantor and you gave it to the trustee, all your possessions, and you do damage with the car, why can't they go to the trustee to pay for the damage that you did with your car? If they can go after the trustee for the money for the taxes of the house, they become
Because
liable.
it's not a damage that they're looking. Okay, so the trust owns the house. The
Yes,
house has a
trustee.
house has a liability to pay property taxes, right? That property has a tax ID number, meaning that it has to pay taxes. Doesn't matter if it's a trust, corporation, individual, doesn't matter. In the car accident scenario is because someone caused an issue. It's a difference. So, like if I'm driving a car and I hit somebody, I'm liable. The trust
Yeah.
is not liable because the trust wasn't driving the car. The tax thing is different. Taxes, property taxes are a whole different beast altogether. Um,
Okay.
it's just a different beast. It's not. There's no legal claim brought in on against the trust in the car accident. There's no legal claim on the property taxes. They're just saying that they technically the federal government took the land and they're using it as collateral to pay or to borrow Federal Reserve to get Federal Reserve notes printed. This is printed off of two things. It's empowered by birth certificates and asset-backed securities, mortgages. Right? The mortgage is a security to back up the public debt. This thing right here. Okay, that's what that's. So that's why those things are taxed. Now, there's ways to get out of the tax exemption. All right, I just use the state constitution. State constitution gives you all the exemptions that you can utilize any exemption in the state constitution to not pay property taxes. It's not very complicated. People make it complicated because people like complexities. I don't know.
Well, I have a land patent on my property. So it's exempt from taxes.
Okay.
I'm also exempt from any municipality privileges, like the fire department.
Yeah, that's right. It would be.
Right, eminent domain, they can't come on here. There's no statutes or ordinances on it anymore.
There you go.
So, yeah, like you said, that's common law though, right? But let me just throw this in so people understand that. And I got this through Rick Martin. When I had asked him, how do I insure my vehicle? He says, you don't insure your vehicle when you're traveling. He says, you bond yourself. So you can go and get a bond from the insurance company because the car doesn't get in the accident, you do. So once you bond yourself for, let's say, okay, so $1 million, I think is $235. And then, it progresses up to about 5 million. That's all they'll give you. So you as a person, as you said earlier, you're the grantor. They go after you and you got to make that person whole. And it's a whole different subject, but I just wanted to throw that out there for you guys. And that's where I think we're at, but I'm not 100% sure. You're more versed with the automobile stuff.
Yeah, I have a bond.
You have a bond on yourself?
I have a lot. Yeah, there are a lot of bonds.
You too. Okay, good. I just want to make sure. All right, cool. Okay.
I've done bonds for me, from the car. I've done all kinds of stuff with bonds. The court, I sent a bunch of, I'm not going to get into it here.
Yeah.
Because we're trying to talk about trusts.
Right.
All right. So, all right. Anyone have any questions about trust though? Like, guys, I want you to speak
Right.
up. This is your class. I want you to talk, ask
Yeah.
questions. Yeah.
So you spoke about revocable trust, you spoke about irrevocable and common law. Express trust, are they the same as common law?
Okay. So that's a great question. So I hear this all the time. I have an express trust. Well, there's two types of trust when you talk about that category. There's implied and express. An implied trust is like, let's say I go to you and I say, hey, I heard your daughter needs a pair of scissors. Here. I give you the scissors. I'm the grantor, you're the trustee, she's the beneficiary. She's going to take the scissors, she's going to use them for what she needs to. She's doing some kind of, I don't know, sewing thing. She's making a dress, right? Well, that's an implied trust. It's implied that I'm the grantor, you're the trustee, and she's the beneficiary. But this is a revocable trust because once she's done, she has to give it back to me. And once I get the scissors back, the trust agreement is gone. That's an implied trust. There's nothing in writing. It's all implied, understood just by human nature. Now, an express trust is a trust that's written out in words, right? It's expressed on paper, meaning that we wrote down the rules. Now everyone can see it. That's an express trust.
That's a good example. That makes sense.
And that's where things get a lot of fun. Okay, when you can write a trust, right? What you're doing is you're writing law. Let's say I want to write a trust for these scissors. I'm going to put these scissors into trust. Like, for example, let's say like a school, a sewing school, right? You buy the scissors for the school. The school is technically the trustee. I'm the grantor. I bought the scissors. I give it to the school, and all the students use the scissors from here on out. Now, this is an irrevocable trust, right? It's an implied trust. I could make it express, but in this scenario, it's an implied trust, but it's irrevocable because I'm never expecting to get these scissors back, right? I just gave it. I say, here, it's yours. As long as it's helping the students, that's all that matters. Now, that's an irrevocable implied trust. But let's say instead of giving the school scissors, let's say I gave them a loan of like $50,000. Now I'm expected to get paid back, but they're going to be the trustee. They're the beneficiaries of that loan, but I should get something back in the end, right? Um, Either get my $50,000 back or get, maybe a little bit extra, maybe an extra 10%, or I get buy into the thing and now I'm part of the business, right? Part of the school. But all the stuff that you write down, that's the express part of the trust, right?
So when you get your item back, then your revocable trust is done, or trying to
Yeah,
figure
the
out.
trust collapses. Like, so let's say, but in the term of the scissors, I give you the scissors, you give to your daughter, she cuts them, right? She gives them back to you to give to me. I take it back. Once I take the scissors back, the trust is collapsed. It's over. And trusts can collapse. Like my guitar education trust, it has 21 years, and in 21 years, the board is going to meet up and make a decision whether we keep it around for another 21 years or not. I think I got like 9 years, right? What did we do?
Awesome.
No, I got 6 years. In 6 years, I have to look at it again because I started in 2010. So, um,
So I kind of understand the grantor, trustee, and beneficiary. The grantor the main person that controls everything,
the it depends on
or
the type of trust. The trustee is the one that really has control over the trust. The grantor is the one that sets the rules of the trust, right? So they make the rules. In a revocable trust, they have pretty much absolute power over the trustee unless it says otherwise in the trust. But for the purposes of keeping it simple, in a revocable trust, the grantor has the final say so about what happens in the trust. In an irrevocable trust, the trustee has the power to act and do all these things, but it has to follow what the trust agreement says. If the trust agreement says that the trustee is not allowed to take more than 10% of the trust funds, right, for their own use, they can't dip into the trust any more than that 10%. If it says that they have to give beneficiaries, 5% every month of the trust funds for their living situation, then they have to do that. If they give 4% instead of 5%, the beneficiaries can sue them. It's a breach of fiduciary duty, like a fiduciary meaning someone who has financial responsibility over something. So that's what a trustee is. They have financial responsibility over this trust agreement, meaning that they have to keep records of everything. They have to do what's written out inside that trust agreement. And if they don't, the beneficiaries can sue. In a revocable trust, the grantor can sue or the beneficiaries can sue, but it's easier in a revocable trust to just get rid of the trustee and get somebody else, right? And that would be it. Say, well, you know what? You're done. You're out of here. Because the grantor can just change and modify the trust at will.
and that's revocable.
That's revocable. That's why I tell people
Okay.
start with a revocable trust, right? And you have it set up, right? You can set up however you want, piece by piece, the amendments, all that stuff, or the articles, and then write amendments as you learn things and go. You go, oh, I learned something. Don't do that, and then you write this down. Okay, this is something we will never do again. Lesson learned. Okay, and that becomes an amendment. The trustee is not allowed to do this, or you say, oh, we should have did that. Okay, amendment number 2. Trustee must always make sure to do this in this scenario, right? Or we learned something else, or we sold property. If you sold a piece of property, right, now you have to decide what you're going to do with that money. If it's not already delegated or delineated inside the trust agreement, then you have to come up whenever the trust sells property, this percentage is going to go to beneficiaries, and this percentage is going to go to acquiring new property for the trust, or just be put into maybe a savings account or something for later on, right? Depending on what you want to do with that. So like if you have like the house, for example, and let's say you're like, you know what, this house is kind of getting run down. It's getting too small. Now we got more kids. let's sell the house and get another one, right? So the trust sells the house, right? Now you say, okay, now it has all this money. The trust has like maybe let's say $400,000. Now you say, well, why don't we just buy another house? We're going to go buy a bigger house. So you go buy a bigger house. That's what it would be, is that it'd be that funds would be held in trust for the acquisition of a new house, and that trust buys the new house. So that means that the new house has always been in trust.
Can you
Okay.
speak to when you, I don't know if in your process you do trusts within trusts, and when you cycle between irrevocable and revocable trusts for the different protections that those different things give you?
Okay, yeah. So I have a revocable trust that I operate through, like on the public side. That's a
Mhm.
revocable trust. Okay, behind that, I have irrevocable trusts, two of them. I have one that holds physical property, and I have one that holds intellectual property.
Okay.
Now, what's interesting is the operating trust actually holds nothing. It just does the functions of a business without being a business.
Right.
And
Okay.
so when someone sues that operating trust, they go, "We're going to sue you for this, and we're going to sue you for that," and they go, well, "We don't have anything." But all right, well, you can sue me, and then they can say, "Well, you owe this and that," and then we claim bankruptcy, and the trust gets dissolved, and I just put up another one in its place,
Okay.
right? But the irrevocable trust can't be sued the way I set them up. Because what happens if they try to sue, let's say the one that owns intellectual property, because I actually have intellectual property, um, they try to sue that one, and I send the judge in the court case. I send it to him in chambers. It's called in camera. I send
Mhm.
him one clause from the trust, and I say, "I'm sorry, I have to inform you that we have a spendthrift clause, and this court case exceeds the amount of money allotted to be spent out of this trust on a monthly basis." And then the judge will go back and tell the plaintiff, "Hey, you can't sue the trust. You're not going to be able to get money from it because you're going to violate the trust agreement." Because this is why trusts are very powerful. Because, like I was saying before, when you create a trust, you're creating law.
Mhm.
And the judge cannot force you to breach the contract of the trust that you've signed.
Can
He's
you
not.
speak to a little bit on so kind of working with parallel structures of wills and how wills can also effectuate that type of scenario, and the nuances of when you might use which?
Okay, so in the case of a will, what a will does is it holds property, right, for specific.
I should correct myself and say living will.
Oh, well, I mean, it's the same thing, really.
Right.
So,
For clarity that people for for people to understand that you can have uh, a will document that's not just predicated on death.
oh, well, the living will, well, okay, the living will is like in the case of like you're in some kind of situation, physical situation that you can't make decisions for yourself anymore.
Right.
Well, I mean that's a different thing. That would be, I mean, that is, I guess you could say that's a trust agreement because you're giving someone else power of attorney
Hmm.
over you in those situations. You know, if you get into like a motorcycle accident, now your brain shuts off. It's a freaking tragedy, you know. And you could say, yeah, you know what, give me 10 days. If I don't come out of it, just let me go. And then you make this person call the shot, which, you know, you gotta, but that would be a type of trust.
Right. So then going back to, I guess it still leaves sort of the parallel structure of a regular will. Um, that might be something to elaborate on in terms of the nuances there.
Yeah, so here's what we'll do. I'll show you. So we have our trust agreement here, right? Grantor holds this property for the benefit of the beneficiaries, right?
Hmm.
Okay. Now, a will, the difference is this. With a will, you have a guy here. Oh, Here's a guy. Okay.
So with a living will, can you extend that beyond medical?
Oh yeah, you could. Yeah, let's say this guy has like trophies or something, right?
Okay, that's what I thought because I've been talking to someone else and I just want to make sure that I'm following what they were saying and then okay, gotcha.
So this guy's got a trophy here. I don't know, with this some kind of whack trophy, but he's got a trophy here. It's worth lots of money. Okay, it's not in trust, but let's say his one son over here always loved that trophy, right? So what he does is he writes up a will, and he says that when he dies, his son gets the trophy in the will. Now, it goes from being his personal property in his name to being his personal property in his name. There's no real, I mean, it's not really a trust agreement, right? This is kind of outside the trust. It's within the trust law realm, but it's a bit of a different kind of thing. So the will is actually protecting this property, right?
Mhm.
From getting taken by maybe maybe a cousin or something over here who kind of wants it with his beady eyes. I'm gonna get it. Right? That guy, he's like,
Mm.
but the will protects him.
Highly emotive stick figures, by the way.
Huh?
Highly emotive stick figures.
Yeah.
Got a superpower there.
So yeah, that's what the will does. So it's protecting this property for him. It does. It's a quasi type of trust, you could say, but it is a bit different because it's still recognized, like this property that's on the will is still recognized to be the property of him.
Mhm.
So let's say he got sued, right? Let's say this guy sues him over here, right? Mr. Shifty over here. He's mad at him too because he killed this cat by accident, car accident, horrible thing. Ran over his cat. He sues him for lots of money. The guy doesn't have money, so he says, "Give me the trophy and we'll call it even." He can get the trophy, and then now the trophy's no longer in the will. They had to scratch it off. Now son's sad because he doesn't get it. Now he can always make a deal later on, to get it back. But that's the difference between a trust and a will. If this
Okay.
if this was in a trust, this guy can sue him and try to take money from him, but he can never get this trophy because the trophy's owned by a trust. He has no claim against the trust. It's against this man
Okay.
that he has a claim against.
Thank you.
That makes sense?
Yep.
Okay.
Can I ask, were you thinking of a living trust maybe?
Who, me?
No, the young lady.
Maybe. Thank you for the
The living
edge.
the living trust is this scenario up here that we're talking about before. Right?
Okay.
Like when he dies, the property doesn't move anywhere. But the trust becomes irrevocable at that point. Right? This is the revocable living trust. A trust that the grantor can change at will and upon death. See, this is a living trust. This trust can become irrevocable
Okay.
because only the grantor can modify this trust. Once the grantor dies, it can't be modified anymore. It means you can't revoke it, you can't alter it. You can only go, you're bound by how it's set up now. The living will is a different thing. I think maybe she did get that confused because I was like, what? But yeah, that makes sense. All right.
Let me ask one more quick question. Go back to your the one you were just at, the diagram. So let's say the beneficiary, let's say it's a irrevocable trust. Yeah, right there. And you give it to your beneficiary, and the beneficiary, God forbid, passes away. What happens with the property if it's irrevocable?
The grantor can assign a new beneficiary.
Oh, okay. Okay.
And if
All
he
right.
doesn't have any beneficiaries, he can assign a trust as a beneficiary.
But you said it's irrevocable now,
Yeah, but
and the beneficiary's died.
right. And look what it says here. You need the approval of the beneficiaries to modify it.
Okay.
But there's no more beneficiaries. They're dead.
Okay, all right, so I wanted to know.
So it goes back to the grantor being allowed, because now there's no beneficiary to oppose it. He puts a new beneficiary in. Those are some of those examples. Like I'm glad you brought that up. That's really important. But that's a scenario where, like, yeah, they go, okay, the grantor has to name a new beneficiary, because without a beneficiary, there is no trust, right? That trust agreement exists because of that.
I get it. Okay, so it just dissolved.
Oh, that's America.
Sorry, Joe, I didn't mean to do that. I was trying to fix it.
So the revocable trust, it automatically becomes irrevocable upon the death of the grantor, or is this something you have to write in?
No.
No, no. Well, yeah, you could put that in the trust. So when you write out this trust, you could determine that if the trust becomes revocable upon the death of the grantor, right? Like, the thing about this trust, when you're writing your own trust, okay, you make the rules of it. It's your trust. Okay, as long as you're the grantor. All right, let me see if I can find one that I could share without giving away anyone's private information.
And then question about putting trust together. I want to make it as simple as possible. And I was listening to a video where they said that you can create the trust and not even put minutes in it. So I'm wondering if there's something like that, or if you know,
Yeah,
if you can
I mean,
explain it.
I have a trust that has no minutes because it's just holding property. So what minutes do we need? But, like, I have an operating trust, so I have books that have the minutes in it. See, and I have all the minutes in here saying what happened, what's going on. There's like little notes in there. What did we do this day? But then I have trust that just holding stuff. So it just, there's no minutes. And someone goes, "How come your trust doesn't have any minutes?" You go, "Well, what did it do? It hasn't done
I
anything."
see what you're saying.
Yeah, like, the
Yeah.
minutes is basically, just so everyone knows, the minutes are basically a recording of the actions that the trust has done. So if I put, let's say, I put a house into a trust, I mean, the only minutes would be showing that the bill, like the taxes getting paid or the utilities are getting paid. You know, that's about all the minutes you're going to have, or repairs done or stuff like that on the house. Or, like, I have, well, like, I have one for my guitars. I mean, there's no minutes to that because they're not, there's nothing,
Okay.
there's nothing to record. It, it's like a journal of the trust, the minutes. I'm looking for, no.
What about the ministry ones, Joe?
A ministry trust, that's a church controlled trust. If you put your house into one of those, it would be tax exempt. You just have to apply for the tax exemption afterwards with your state, and they'll give it to you.
Like the 508C1A, is that it? That's what I was looking at too.
The 508c1a,
For
yeah,
traveling.
yeah. 508c1a, no, yeah, that's a trust, but
It's not a 501, see, for churches?
a 508c1a is a church, right? If that church is the grantor of a trust, the trust is also considered tax exempt because it's a church controlled trust.
They mention ministry, so ministry or church, like if you're going around, kind of like under natural law, we are, you know, speaking of, God and, living under natural law, the private. So, that's how I saw something. I think I researched it and it said that you can be like someone that's passing on the word of God or something like that, and educating people about natural law.
Right.
and living in the private.
No. I know I have one. What is this it? No, that's just a certificate. So I'm looking for a trust that I can show you guys so you get an idea. What about this one? No. You know what? Let's do this one. Here's what I'll do. All right, cool. I just blanked out the names here. I'll show you. So this is a living trust. Okay. The purpose, right, is to establish a trust and receive and manage assets for the benefit of the grantor during the grantor's lifetime, and to further manage and distribute the assets of the trust upon the death of the grantor. So this is a living revocable trust, right? Oh, shoot. I forgot to cut out the names. Hang on.
We can't actually see them, or at least I can't on my
Okay.
screen. It's
Well,
jumbling.
that's fine. I
So-
mean, I'm just going to do this. It's at least for my own sake, so I don't feel like I'm, you know, violating somebody's privacy.
Yeah, no, it's important. Trust should be private. I'm just trying to give you some comfort in that I don't think it's showing, at least not on my screen, it's not. It could be that because I'm on an auxiliary screen, so you want to check in with other people and see if they can read it.
Yeah. Well, I'm just going to do a couple more, and then I think we'll be all right. Okay, that's good. All right. I just won't, once we get to the signature page, we just won't show anymore. Okay, fine. All right. Better now. All right. So this is a trust between these people, right? See, one's a grantor up here. Okay. Oh, damn. And then the other is a trustee. Okay. Yeah, see, grantor, and then the trustee. All right, so that's the purpose. This was set up so that way it was for a woman to give all her property over to her son when she passes away, essentially, is what they're doing. So we set up this trust for them for that purpose. She was divorced. Out of the divorce, she got a bunch of stuff, and the husband got other things, and they kind of just split things. But she wants to turn everything over to her son. That's how that's grantor's transferred, assigned, conveyed, and delivered to the trustee. So she's giving it over to her son now. Like she's not holding on to any of this stuff. The property described in Schedule A. So Schedule A is a list of all the things that's owned by the trust now. But you see, even though it's the funding of the trust, the grantor is giving it over to the trustee. And that's the property, right? So the Schedule A is going to be a list of everything that's in there. The management of the trust assets, okay, shows how the trust assets are going to be managed. The trustee shall pay all the net income of this trust. We put that in there because one thing was that she owns a business, right? The son is actually learning, he's operating the business and learning how to run it. So we said, like, if we put the business into this trust, that she's still going to get paid anyway out of this business. So the trust is going to have to make payments. They didn't sort out how often she would get paid, so I left it blank. I said, you just write it in later. She couldn't make a decision. If the grantor has a disability, the trustee may pay to or for the benefit of the grantor, right? We're talking about support, comfort, welfare. So you see, like this is a living trust. What this is it's ensuring that the grantor is protected throughout this trust, because even though the property is now in possession of the trustee for the benefit of the beneficiary, the grantor still holds these assets in some regard. So it's not fully given up by the grantor yet. Okay, that's why the revocable living trust can be sued and stuff like that, where the irrevocable trusts have a harder time getting sued. Right? Like as a grantor getting sued and penetrating the trust, he can't do it with the irrevocable because that's not his. But in this case, the grantor is considered to still have some kind of ownership over the property. All right. Upon death, the grantor, right, after the payment of the grantor's debts, funeral expenses, and expenses of last illness, right, I put the name in there again. I missed one. All right. It's going to go to these beneficiaries. 100% goes to this beneficiary. She only had one beneficiary, which was her son. So the son was going to get everything either way, but he's already acting as the trustee now. So he has to assign a new trustee in the future. So what we said we were going to do in his scenario is put a trust there as a placeholder for a future beneficiary, because he wants to have kids, but he's not ready to have kids yet. All right. Retaining assets, dispose or encumber assets, settle claims, right, that are against the trust. And their business has kind of a thing where they might actually get, get lawsuits. Probably nothing major, just stupid little things, right? Manage real estate, personal property, borrow money, right? But you get how this works? Like, this is the law. So, like, if someone tries, let's say a judge says, I want you to, you're not allowed to enter contracts anymore under this trust, right? Well, they can't do that because this trust is allowed to enter into contracts. So a judge can't come in and alter a trust unless it's a public trust, like a 501c3, like one of those like public charities. A judge could come in and go, no, we're going to make you do this now. You're going to have to do that. Your trust needs to do these things. That's why I don't like 501c3s, because they're public entities and they're at the discretion of the courts and the public eye. And if someone says show your books, they have to show all their bookkeeping. So those 501c3s are not the way to go if you really don't want to. Now, stock ownership, right? Stuff like that, duration. You can hold trust assets into a single fund, right? In this case, we did that because the only thing that was going into this trust was the business, and I think one of her personal accounts. I think that was all that this trust was actually taking over, because she didn't have much more than that. Like they had a house, but they sold the house from the divorce, so they're like whatever, and then the money they split, and she was putting that money that she got from the house sale into the trust along with the business that she had. Like her husband got, I forget what he got, but they split the house. She got the business. They were running a business through the divorce. He said, just, I'll tell you what, you keep the bit. Oh, I remember, he didn't have to pay alimony if she got the business. So he gave her the business. He doesn't have to pay alimony. That was it. I remember now. Okay. That was the agreement. So she got the business. And so we just held that in one single fund. All right. Loans to beneficiaries, to make loans to trust beneficiaries for the purpose of providing the beneficiary with the funds necessary to take advantage of exceptional business opportunities, such as, like, let's say the son who's now running the business goes, oh man, you know what? If we could get like another $20,000, we could expand the business and we can add these features in there. Like, oh, this would be great. We got a great opportunity. We got a great deal. I got a bargain right now. So the trust will say, yes, let's give you that loan. So that way you can, use that opportunity to grow the business. All right. Additional provisions. If at any time the grantor is the trustee, the grantor may appoint a successor trustee to become effective immediately or upon any stage contingency. So, and there's more stuff to that. Like I said, there was no successor trustee. All right. Accounting, no bond shall be required. Some trustees have to be bonded in order to act, so that if they violate the terms of the trust, they have to pay out of that bond and then they have to step down as trustee. But in this case, we weren't doing that because, well, she's trying to make life easier for her son. So that's an example of a living trust and how it works. Right? Anybody have any questions about that?
You mentioned it was harder to sue. So what you're saying, you could pierce the veil, or you could sue if you still have a trust,
Oh
or
yeah,
be
trust can be sued. Yeah. Um, like okay, so let's say I got like my guitar education trust. It's not. No one's gonna sue it, right? Because there's nothing to sue. Like what am I? I'm selling guitars and equipment and doing lessons. What's there to sue? It's a very low risk type of business. So I specifically wouldn't have a lawsuit. But if you're driving a car around and the car's in a trust, and let's say the car gets into an accident, they could sue that trust.
yes, okay,
And they could sue the driver and they could sue the trust. You could say, well, the trust property, we want, damages out of the trust. But that's why I say if you want your cars in the trust, just make a trust just for the car. So that way it doesn't penetrate any other trust.
okay.
And those can be very simple, just real simple. Like I'm the grantor, these are the beneficiaries, and this is the trustee. And the property is the car.
If you put the car you say you gave you put the car in a trust, who would be the trustee? The children?
Yeah. You could say guests. Any guests that I have in the car would be a beneficiary.
Okay. So if they sue the trust for the car or the damage that the car did or you did, they go after you, you got nothing. And if the car is in a trust to the children, do they sue the children then?
No, because the children aren't a party to the incident. They would just say that's not a party. You can't sue them because they weren't involved. They weren't directly involved in the accident, so they don't have anything to give them. Beneficiaries can't really be sued.
Okay. All right.
That's another thing about an irrevocable trust, is that you can't be the trustee and the grantor, but there's no rule saying you can't be the grantor and the beneficiary.
Oh, oh,
Mm.
ah. That's-
So you put property into an irrevocable trust. You assign, let's say you make your wife the trustee. It's an irrevocable trust, right? Now, they want to sue the grantor. You say, oh, can't sue the grantor. It's an irrevocable trust. That's in a trust. Then they go, oh, we don't have a claim against. But you know what? We're going to sue the trust anyway. Let's get the trust. And then they go after the trustee, and the trustee is the wife. And she's like, I don't know. What's this about? And they go, well, we're going to sue you for $20,000. And then you're the beneficiary. You're just like, well, I can't get sued. And my wife is fine because all she has to do is show the court the spendthrift clause and say, I'm sorry, but this exceeds our the allotted amount that we're supposed to pay out of this trust. And if the judge says he doesn't care, well, he violated the trust agreement and he can get in trouble for that. But he won't do it. They're not that stupid. Like some of these judges are a little out there and they definitely like feel emboldened by because the people just lack knowledge out there, but they won't do that because they're going down a dark path for themselves. They can get disbarred. So all you gotta do is bring a claim against them in the bar courts, right, in Washington D.C.
Mhm.
They'll lose their bar card. They won't be able to be a judge anymore.
Hmm.
And you just write to them and say, hey, look, I might have a suit against the judge because he forced me to go against my trust agreement. Now I have injury because I had to be removed as trustee and the trust got penetrated. It violated its own agreements. And they go, We need to look into this. This is the problem. You can't do that. He could get disbarred. So they won't go down that slope.
So the husband puts the wife as a trustee and then he puts himself as the beneficiary.
Could do that. Yeah, you could do it that way.
That's what you just said. So then, okay, all right.
Yeah. Yeah, I said it that way. You could do it a lot. Like me and my friend, we do it with each other. He lives in Ohio and I'm here. And what we did was he bought a house and then put it in an irrevocable trust, and I was the trustee.
Okay, but he's
So, so nobody knows. They don't know where he lives because his name's not on the property at all. But he's the beneficiary of that trust.
okay, all right, good. All right, just curious. Okay.
Can you,
Is that a revocable, irrevocable?
It's irrevocable.
Irrevocable, okay.
Yes. What were you gonna say?
I was going to say, can you speak to where, because I've heard mixed things on the idea of the grantor also being the beneficiary.
Mm-hmm.
And I'm wondering if you could maybe, you know, I don't know if it's in Weiss or if it's somewhere like that where it sort of spells out that that's okay.
Oh, it's probably written in Weiss Concise Handbook. I don't remember exactly. But a revocable trust, the grantor cannot be the beneficiary. The
So it's just with an irrevocable one.
with it right. So
I
the
got you.
it works like this: revocable trust can be the grantor. Irrevocable, the grant or excuse me, in a revocable trust, the grantor can be the trustee, but not the beneficiary. In an irrevocable trust, the grantor cannot be the trustee, but can be a beneficiary.
Hmm.
So it just swaps out which role they can play. Revocable, trustee, irrevocable, beneficiary.
Write that down. Revocable
The grantor can be the trustee.
and irrevocable.
The grantor can be a beneficiary.
Okay.
And they don't have to be, right? They can just be the grantor and go, okay, I'm done, right? And walk away from it. It's not their problem anymore.
Thank you.
Beneficiary.
All right, so I think I'm going to have to wrap this up because I do have students coming. I wouldn't mind doing another 5 hours with everybody personally.
Okay.
But I'm going to show you guys something. This is obviously you're going to all, since you all paid for this class, you're going to get a link for it. Okay. But I'll let you guys know something that I will be also, where is it? I can't find anything now. Oh, that's why. I also have a group here, and this video will be up in this. This is called the Liberty Foundation. Okay, and it's my group. It's a small group of people in here, not a lot of people. See, I'm saying as a token of my appreciation, I'm hosting a Trust 101 class for a few sovereigns from another group. That's you guys. All right, I will post that class here for free for all the members. Thank you all for being here with me. So I'm giving this to them for free, as because they're part of my membership here. Okay, we do have like classes. We're going to build out more classes. But if you were to join here, you would actually get part of this. You would obviously get this replay over and over again. And then what other courses? We have this course here. I'm going to work on a few other courses. We just won hey, everyone, I just had a victory with someone. I was working on 2 credit card cases. Same person. She had two credit card companies suing her at the same time. Okay, we won both of them for over $15,000 of debt. I'll make a class on how to do this soon. So that's going to be another class that I'm gonna have in our Liberty Foundation here. So
Awesome, Joe.
Thank you, Joe.
you're welcome. So
Thank
I will
you.
share you. Yes,
Thank you.
yeah, you're welcome. So I'm going to drop in the link here for you guys to join if you would like to join. All right, I'd be happy to have you guys. Since you guys all follow Roger, I know you guys are level-headed people. Okay, like these other some of these other groups Some of these people get really out there, man. I'm like,
Oh my God.
Keep it simple, people. Keep it simple.
yeah. But I know Roger's got a strong group of very level-headed, grounded, analytical-minded people. So it would be you guys would be a great addition to have there. And it's very small right now. There's only a few people in here, so and I personally know everybody that's in the group. So I'm like, everyone here is really cool and pretty informed and wants to keep learning. And we're gonna do this thing. I'm gonna show how to win civil cases because
Oh, good.
oh yeah, the civil case I got a whole system for it now. It's like there's a step-by-step thing that you do, right? And if you understand all these elements of what a civil case needs in order to win, all you have to do is look at what's missing and go, Judge, this is missing. Judge, this is missing. Judge, this is missing. They don't really have a claim, do they? And the judge goes, You're right. What do you want to do? I want to dismiss this. Okay, we'll dismiss this case. And it's pretty like bing, bang, boom, boom, boom. I've been doing this for a few years now with a lot of success. And that was just one that happened yesterday, which was awesome. She just sent it to me. She goes, "Look what they sent me." And I was like, it wasn't the court that dismissed it. It was the plaintiff. The plaintiff withdrew the case. Said, "We're going to dismiss this case." And the judge said, "Okay, fine, whatever." He don't care.
Are you doing that through equity?
Nope.
Okay.
I mean, I've used some equity maximums in the paperwork a little bit, but really what it came down to was the essential elements of a civil case, identifying what they all are, seeing if they were in there, if the plaintiff actually brought all the essential elements to prove their case, and then shooting it down, right? And using very valid, good arguments to do so.
I
And
have someone
go
who
ahead.
I have someone who is just the sweetest person in the world, and somehow he has very bad luck with companies kind of acting fraudulently towards him. And he applied for a credit card. He actually didn't use it. But he paid a bill that they sent him because he thought it was a different bill. He never activated the card, but he paid that an initial bill thinking that that was his bill because he got confused. Someone had activated the card and done a money withdrawal, and now they're suing him for, I think, $1,800. And he wasn't even in the country, and it was in Missouri, and he's in California. And like he gives every dollar he has to like people on the street. Like it's just he's like the sweetest guy, and this kind of stuff, parking tickets, all this stuff all day long. And I'm trying to figure out how to help him.
Two things you could do. One, you
Okay.
can have them join the group. And
Okay.
we'll go over that stuff because we're going to have live meetings in here. We're going to do Zoom calls as well. All that stuff's going to be recorded. I'm going to also teach how to do that stuff. And I do one-on-ones with people, like the woman that won these two credit card cases. Those were done on one-on-one, sessions. She
Okay.
sat there, she showed me what they gave me. I looked at it, I said, okay, let's do this. Here's our best plan of attack for this. Here's our best plan of attack for this. And then help her put the paperwork together and then say, okay, let's see how they respond to that. And this is the last thing they sent us was an interrogatory, which was a list of questions that they wanted answered because really they were at a point where they couldn't prove the case. So they want the defendant to do it. And they know that stupid people are going to, like, most
Right.
people are not intelligent enough to answer these things in a way that doesn't incriminate them.
Right.
So she gave me the interrogatories. I gave her back answers. They withdrew the case. They dismissed it based off of those answers. So that's what did it was the interrogatories.
So, he was given interrogatories, which I assisted him with very carefully. It would have been better not to answer them at all.
No, you got to answer them because
Okay,
they
so
put. I'm gonna show you one. I got one. Hold on, where is it? Because this just happened, so I have all the paperwork right here. Where is it? That's the dismissal. This is the discovery. Okay. Okay, here, I'll show you. This was the interrogatory. This is what I wrote. Yeah. So, admit that plaintiff is duly organized under the law. Objection, defendant has no personal knowledge of plaintiff's corporate formation, registration, or standing in Missouri. This is like one of the stupidest questions you can ask. Like, how am I supposed to know that you're duly organized under the law? I'm the defendant. How am I supposed to? I don't have. So, but you got to answer professionally. So I said objection. Right? Plaintiff is put to strict proof thereof. I want you prove it. It's not for me to prove. You prove it. Right? You want me to prove. And look, we also use the Missouri rules, the court rules as well. Plaintiff is the true owner of the account ending in this. Plaintiff has produced no admissible evidence of assignment, bill of sale, or ownership under Rule 55.03. Defendant demands production of the original contract and chain of title. That was our response to that. So you got to, the more you look at these interrogatories and try to really understand what are they asking you, right? Look at what they're asking. They're asking you to prove their case with that question. Prove our case. Because if you answer, yeah, you're the owner, they go, bang, we got you. Now you have to pay us.
Yes. Okay.
Well, I think what happened with him is because he accidentally paid the initial bill in error, even though that was explained in the letter, that creates a sense of ownership and claim on you're agreeing to it. You're saying this is mine, and he didn't realize that it was a different account, but he hadn't even opened the envelope, and somehow they activated it. And someone had suggested doing a UCC filing of fraud, because that's something they don't really like. But I've lost touch with that person, and so I'm not sure if that's really I don't know.
What you're saying is he was, when he paid it, he was admitting guilt as if he did owe it.
Right.
Right.
Even if it's accidental.
Mhm.
So,
Yeah. Can I ask you a question, Joe? Real quick. So you won this case, the civil case. Now that you won the case, okay, how do you proceed in suing if you won?
I can go back and say if they violated certain parts of like the Consumer Credit Protections Act, I can sue them on that. We didn't do that in this case because we just wanted to get rid of it. But
No, you missed the point. No, I'm sorry. Let me put it this way. If you went through court and they lost, they went to charge you and you had a fee schedule in place and they had a judge that said, yeah, they violated your rights. It got remanded and it went back as a non-suit. Now they've already lost the case, but I've wasted a lot of time. So now I need to be compensated for my injury. How do you do that? Do you know what the procedure is?
well, if you have an assumed name certificate showing that you're using that name, the one that was being sued for business purposes, you have a right to go and send them your fee schedule and then invoice them for that.
They had the fee schedule already.
Assume name is the first thing. You need that before you can do anything else. If you don't have an assumed name, you don't have standing to sue them because you're not using that name for business purposes. So you have to have the assumed name first. Once you have that, now you have standing as a commercial entity to sue them back, right? Because they have their fee schedule and you invoice them. They did operate and perform the things on the fee schedule at that point. Now you have grounds to sue them for breach of contract. Okay, so I have to go because my student is here. But
Okay, all right. You know what? Yeah, I'll get in touch with you. I'll get in touch with you.
Yeah, but that's a whole other thing.
Thank you,
And
Joe.
I will be teaching how to do that inside the Liberty Foundation. So
Oh, okay,
Thank
cool.
you, Joe.
Thank you so much, Joe.
yeah,
Yeah.
you're welcome.
Thank you, Joe.
Thank you, Merca, for getting me there too.
Yeah. But
You're
we
welcome.
will be doing that in the Liberty Foundation. I'm going to be teaching, so I have a trust community, which we deal in trust stuff, but the Liberty Foundation is going to be covering way more stuff because the trust community just really is centered around trust, and I can't just be restricted like that. So I'm doing this community, the Liberty Foundation, so that way we can do stuff like the lawsuits, the assumed name, suing these guys for wasting your time.
Yes.
That way you have standing grounds against them, and the fact that they violate your fee schedule while also getting quote unquote the services from the fee schedule off, that's off your fee schedule, you know, that also puts them in a bind where they have to pay you. And then we have a whole system for doing that. And once they default on that, then you can sue them in court, and then they have to bring their claim and stuff like that. You know, they have to prove no claim, which they can't do at that point, and you'll win.
Okay, cool.
And then they'll put you on a list, so that way those companies don't mess with you anymore.
Sounds too good to be true, but
Oh. Well, the debt collectors did that with me. They don't send me debts anymore. You know, I can go run amok on like on payments on things and have it sent to debt collectors, and they just won't bother me.
okay. All right.
Thank you. Have a good day, Joe.
Thank you, Joe. So
Thanks, everybody. I'll see you guys later. And when I have this video uploaded on YouTube, I'll send the link out to America, and she can share with all you guys. All right.
perfect.
All right.
Thank you.
Awesome. Thank you.
All right, you guys. Thanks for hanging out with me.
Go make some music.
Oh yeah.
Take care.
We're gonna
Thank
rock
you.
out right now. Bye.
Bye bye.